My mother smiled when my brother slid the documents across the lawyer's table. She actually smiled. She reached over and squeezed his hand like he'd just won a hockey scholarship, not like he'd spent the last 8 months quietly stealing everything my father had left behind. I didn't say a word. I just opened my bag, pulled out a folder of my own, and set it down in front of the estate lawyer. That was the moment my brother's expression changed. But I'm getting ahead of myself. Let me take you back to where this really started, because the theft didn't begin when my father died. It began long before that, in the way my parents built 2 completely different futures for their 2 children, and only one of us knew it. My father passed in October, just after Thanksgiving. He'd been ill for almost 2 years, a slow decline that gave us all time to prepare emotionally, but somehow never felt like enough time when the end actually came. He was a quiet man, a civil engineer who'd spent 30 years working for the city of Hamilton and had saved carefully his entire adult life. The house in Ancaster, a 4-bedroom with a deep lot backing onto the escarpment, had been paid off since I was in university. He also had an RRSP that had converted to a RRIF in his late 60s, a small pension, and a non-registered investment account at RBC that he'd built steadily over decades. Nothing flashy. Just the careful, deliberate work of a man who believed in leaving his children something real. He left it to us equally. My brother and me, 50-50. He'd told me this himself during one of the last good afternoons we had together, when he was still lucid and sitting up in the hospital bed my mother had arranged in the sunroom. He held my hand and said, "I've tried to be fair, sweetheart. The will is clear. You and your brother, equal shares." He looked at me with something I could only describe as apology in his eyes, and I didn't understand it then. I do now. My brother is 3 years older than me. He's always been the one my mother called first, consulted most, celebrated loudest. When he got his real estate license, she threw a dinner party. When I finished my CPA designation after 3 years of working full-time and studying nights and weekends, she sent a card. I'm not saying this to seem bitter. I made peace with the imbalance a long time ago. I built my own life. I have a good job with a mid-size accounting firm in Burlington, a condo I own, and friends who actually show up. I stopped needing my mother's approval sometime in my early 30s, and letting go of that need was honestly one of the best things I ever did for myself. What I hadn't let go of was the assumption that the imbalance was emotional, not financial. That was my mistake. My father's estate went into probate in November. My brother, who had power of attorney before my father died and had been managing the finances for the last year of his life, volunteered to act as estate trustee. My mother encouraged it. "He's good with this kind of thing," she said. "He deals with properties all the time." I had no real objection. I was grieving and I trusted that the legal framework would protect both of us. The will was clear. The lawyer had a copy. What could go wrong? I found out in February. On a Saturday morning I'd taken off to finally go through the box of my father's personal papers my mother had sent home with me after the funeral. Most of it was sentimental old cards, photos, his engineering certificates, a letter he'd written to my grandmother that was never sent. But near the bottom of the box was a stapled packet of papers I didn't recognize at first. It was a loan agreement, dated 14 months before my father died, when he was already ill and had limited capacity. The borrower was my brother. The lender was listed as my father's non-registered investment account. The amount was $87,000. The interest rate was 0. The repayment terms were listed as upon sale of the Ancaster property. There was no signature from a lawyer. No independent legal advice notation. No indication my father had received any counsel before signing. I sat at my kitchen table for a long time with that document in my hands. Then, I made myself a coffee. I needed something to do with my hands, and I read it again. And again. Then I called my friend, a paralegal who works at a firm in Oakville that handles a lot of estate litigation. I'd met her years ago at a continuing education seminar, and we'd stayed close. I asked if I could come over. She read the loan agreement twice without saying anything. Then she looked up at me and said, quietly, "This is a problem." We spent that afternoon going through everything I had access to. The estate accounts had been opened at TD in my father's name with my brother as estate trustee. I was a beneficiary but had no direct access to transaction records without requesting them formally. But I had my father's last 3 years of paper statements, which he'd kept in a filing cabinet my mother had given me. My friend helped me trace the money. The $87,000 from the investment account had been transferred to my brother in 2 installments, 11 months apart. My brother had been withdrawing cash from my father's day-to-day account in amounts just under $10,000, repeatedly, over the last 18 months of my father's life. Small enough to avoid automatic flags. Regular enough to suggest a pattern. By the time I cross-referenced everything, the number I was looking at was somewhere north of $140,000 between the loan he'd formalized and the withdrawals he hadn't. I thought about calling my mother that night. I sat with my phone in my hand for 20 minutes. And then I remembered the look on her face every time my brother needed help, the way she rearranged her life around his schedule. The way she'd once told me that I was the strong one, like that was a compliment and not a quiet way of saying she'd decided I didn't need anything. I put my phone down. I was not going to call my mother. Not yet. My friend connected me with an estate litigation lawyer at her firm, a woman about 15 years older than me who had the kind of calm and precise energy that made me feel like I'd brought a problem to exactly the right person. We met on a Tuesday evening. I brought everything I had. She listened without interrupting, asked clarifying questions, and at the end of the meeting said, "You have a strong case. But I want you to understand what we're dealing with, before you decide how to proceed." What we were dealing with, she explained, was a potentially fraudulent loan executed while my father had diminishing cognitive capacity, combined with what appeared to be systematic misappropriation of estate funds. In Ontario, estate trustees have a legal obligation to act in the best interests of all beneficiaries. What my brother had done, if the paper trail said what it appeared to say, was the opposite of that. She recommended we request a formal accounting from the estate, which is a legal right I had as a beneficiary, and that we do it through proper channels before confronting anyone directly. I agreed. I also told her I wanted to understand the full picture before the estate settlement meeting my brother had scheduled for late March. He'd sent an email to me and my mother with a proposed date, suggesting we all come to the lawyer's office, the estate lawyer he'd chosen, not my father's original lawyer, to finalize the distribution. Something about the cheerful tone of that email made the back of my neck go cold. The formal accounting request went out in early March. My brother's response came back within a week, through his own lawyer, a fact that told me he'd already anticipated something like this. The accounting was provided, but it included the loan agreement as a legitimate estate debt, listed as money owed back to the estate upon sale of the Ancaster property. In other words, he was acknowledging the $87,000, but framing it as an official loan that would be repaid. Presumably reducing his share of the estate but not eliminating it. The cash withdrawals were listed vaguely as caregiver expenses and household management fees compensation, apparently, for managing my father's affairs while he was ill. My lawyer read the accounting and shook her head slowly. "He's trying to legitimize it retroactively," she said. "The problem for him is that caregiver compensation requires prior consent from all beneficiaries or court approval. He had neither. And the loan agreement has serious capacity issues." She had already arranged for a forensic accountant to review everything. The accountant found 3 additional things my brother's accounting had obscured: a $22,000 transfer to a joint account held in my brother and his wife's names, a $15,000 payment to a numbered company that we traced back to my brother's real estate business, and a discrepancy in the valuation of the Ancaster property. My brother had obtained a low appraisal that would minimize the estate's value and reduce what I was entitled to. By the time the March settlement meeting arrived, I had a complete picture. I had retained my own lawyer. I had a forensic accountant's report. I had a title search on the Ancaster property showing that my brother had, in January, filed paperwork to begin a survivorship transfer, a process that, if completed, would have moved the property into his name using a legal mechanism that wasn't actually applicable to this situation. It had been flagged and paused by the Land Registry Office, but he had tried. He had actually tried to take the house. I want to be honest about how I felt during those weeks. I wasn't just angry, though I was very angry. There was something underneath the anger that was harder to name, a kind of grief that had nothing to do with losing my father and everything to do with losing the version of my family I'd wanted to believe in. The version where the imbalance was just a personality difference. Just my mother's particular way of loving, not a deliberate architecture designed to funnel everything toward one child and leave the other to fend for herself. Sitting with those bank statements, I understood for the first time what my father's apology had really meant. He'd known. He'd known what my mother was capable of, and he'd tried to fix it in his will, and my brother had simply started stealing before the ink was dry. I didn't cry about it, not then. I cried later, alone, after a run along the waterfront on a cold March evening when the lake was still half frozen and the sky was doing something extravagant with the sunset. I let myself feel it fully for about 40 minutes. Then I went home, showered, and made a list of everything I still needed to prepare. The day of the meeting, I got there 15 minutes early. The estate lawyer's office was in a mid-rise on King Street West, the kind of space that looks expensive without quite being lavish. The sort of office where a lot of difficult family conversations happen over conference room tables with a water pitcher and a box of tissues nearby. I introduced myself to the receptionist and was shown to the boardroom. My lawyer was already there, which we'd arranged. She had set up her materials neatly on one side of the table. I sat beside her, put my bag on the floor, and did not take out my folder yet. My brother arrived with his wife. I hadn't seen her since the funeral, and she looked different, thinner, I thought, and her smile, when she greeted me, didn't quite reach her eyes. My mother arrived 2 minutes later, already talking, filling the room with the particular kind of noise she makes when she's performing confidence she doesn't quite feel. She kissed my brother on the cheek first. She nodded at me. The estate lawyer, my brother's chosen lawyer, opened the meeting by summarizing what he called a straightforward distribution based on the accounting my brother had provided. He outlined the estate's assets, the proposed distribution, and the timeline for finalizing the sale of the Ancaster property. He used the word straightforward twice in the first 3 minutes. My lawyer waited until he finished his summary, then said, clearly and without any particular drama, "We have some concerns about the accounting, and we'd like to walk through them." My brother looked at me. Not at my lawyer, at me. And the look on his face was not guilt. Not yet. It was the specific expression of someone who has always been the favorite and cannot quite believe that the ordinary rules might apply to him. I opened my folder. We went through it methodically. My lawyer presented the forensic accountant's report. She outlined the capacity concerns around the loan agreement. She addressed the cash withdrawals and the lack of prior authorization for any trustee compensation. She presented the title transfer attempt. She was calm and precise and did not raise her voice once. My brother interrupted twice. His lawyer put a hand on his arm the second time. It was the moment we got to the joint account transfer, the $22,000 that had moved into the account he shared with his wife, that something shifted on the other side of the table. I was watching my sister-in-law because my lawyer had told me to watch her, and what I saw was a woman who had just heard a number she didn't recognize being attached to an account that had her name on it. She turned to my brother. "What joint account?" she said. He said her name, quietly. She said it again. "What joint account?" Because here is the thing my lawyer had found during the title search. My brother had, sometime in the previous year, opened a second joint account with a woman who was not his wife. The account we had traced the $22,000 to was not the household account my sister-in-law knew about. It was a separate account, at a different institution, that simply also had joint in the documentation, joint between my brother and someone else entirely. My sister-in-law had not known she was sitting at a table that would change her marriage. She had come to the meeting as my brother's supporter, the person who would smile and nod while the family money was redistributed. She left it as someone with her own set of questions that had nothing to do with me. My mother had been quiet for a long time by then. Not the aggressive, quiet of someone choosing not to speak, the stunned quiet of someone who has been handed information that doesn't fit the story she's been telling herself. She had spent 40 years protecting my brother from consequences. She had smiled when he slid those documents across the table. And now she was sitting very still with her hands in her lap, and the only thing I felt watching her was tired. Not vindicated, not triumphant, just tired, and a little sad, and very certain that I had done the right thing by not calling her in February. The meeting did not end neatly. These things never do. The estate lawyer asked for a recess. My brother stepped outside with his lawyer. My sister-in-law stayed in the boardroom and did not look at me, but after a few minutes, she said, very quietly, "I didn't know about any of this." I told her I believed her. I think I did. The formal resolution took several more months. My brother ultimately agreed to a negotiated settlement, full repayment of the misappropriated funds, a corrected estate accounting, and an independent appraisal of the Ancaster property. He did not face criminal charges, which was a decision I made after a long conversation with my lawyer. Pursuing that path would have meant years of proceedings, significant stress, and uncertain outcomes, and what I wanted was not punishment, it was what my father had actually intended me to have. I got that. The house sold in June for $890,000. My share of the estate, after proper accounting, was just over $340,000. I put $250,000 into a down payment on a house in Burlington, 3 streets from the lake. The rest went into a TFSA and a non-registered investment account. I have a financial planner now, someone my colleague recommended, a practical woman who talks to me like I'm capable of understanding my own money, which I am, and which not everyone has been kind enough to assume. I haven't spoken to my brother since the settlement was finalized. I don't plan to. This is not a dramatic declaration or a permanent punishment, it's just a boundary that makes sense right now, maybe forever, and I've stopped needing it to feel more complicated than that. My mother called me 3 times after the settlement. The first time, she said that I had humiliated the family. The second time, she said she hoped I was happy with myself. The third time, she was quiet for a moment and then said, "Your father would be upset." I thought about that for a while after I hung up. And I decided that no, actually, he wouldn't. I think he'd recognize what I'd done. I think he'd seen enough of how this family worked to understand that sometimes protecting yourself and honoring someone's wishes are exactly the same thing. I drove past the Ancaster house the week before the new owners took possession. I parked at the curb and looked at it for a few minutes, the lot, the big maple in the front yard that my father used to rake every October with enormous theatrical complaint, the sunroom where we'd sat together that last good afternoon. I let myself feel the loss of it. The real loss. Not the loss my brother had manufactured, but the genuine grief of a place where someone you loved used to live. Then I drove home. There are things I wish someone had told me before any of this happened. I wish someone had told me that being named as a beneficiary in a will doesn't mean you'll automatically receive what you're owed, that estate trustees have legal obligations, but that those obligations require active oversight to enforce. I wish someone had told me to request a copy of the will independently, not wait for it to be provided, and to consult my own lawyer before any estate meetings, not after. I wish someone had told me that the combination of grief and family pressure is one of the most reliable ways people lose money they're legally entitled to, because it's hard to fight for yourself when you're still crying in parking lots about someone you miss. If you are a beneficiary in any estate, get your own legal advice before you sign anything or agree to anything. Request a formal accounting. Understand what the trustee is legally required to provide and by when. These are your rights under Ontario law, and exercising them is not aggressive or adversarial, it is simply what it means to take care of yourself when someone else is in a position of power over money that belongs to you. My father tried to leave us something equal. He did his part. The rest was up to me. I'm glad I showed up,